Out to everybody, whether you start your own business or you're working for somebody else and you have anything to do with contract negotiation, it is important for you to indicate that if in fact you have entered into a contract and the party you're negotiating with can't pay for a certain movable or a good, then you have them sign in the contract an acknowledgement that this is a secured contract. Now I'll talk about what a secured contract means in a bit, but according to United States bankruptcy law, secured creditors have priority over unsecured creditors. So if you could bargain in your contract to suggest that it's a secured transaction, which means that there's some collateral behind that transaction, you'll be in a better position. Because if you're dealing with an unsecured transaction or an unsecured debt, you have much less leverage vis-a-vis protecting your financial situation in the case of insolvency with respect to the party you're negotiating with. And I'll give you an example. It's a little bit nuanced, but let's say that Edgar goes into a Target store and buys some products with his Visa card. That is an unsecured transaction. If for some reason Edgar doesn't pay his credit card bill, and I know he always would, because he's a very dependable person, very reliable, but if for some reason he decided to simply keep the stuff he bought at Target and not pay his Visa bill, Target will not come after him. Visa might. Visa could sue him. His contract is with Visa, and Target is a beneficiary of that contract. We call that a third-party beneficiary. If we change the facts ever so slightly, we could turn that unsecured transaction into a secure transaction. All we would have to do is have Edgar using a Target card. That is a card that is issued by Target to purchase products at Target stores. You might have the same thing at Sears or Home Depot. Once you use their in-house credit card, the terms are indicated on the back of that card. Your contract is with the card company, whether it be Target, Home Depot, wherever you're purchasing the goods. Now, from a consumer's perspective, it's typically more advantageous if you have an unsecured relationship, because they're probably not going to come knocking on your door and say, "Hey Edgar, I want that refrigerator back that you bought at Target for your dorm room or your fraternity," wherever you have it. Now, if you have a secured transaction and you try to file for bankruptcy, whether you're a consumer or a business, there will be something called a meeting of creditors after you file bankruptcy. I'll talk about the procedure in a few minutes. But what could happen is if you're dealing with a secured creditor, they could come in to the bankruptcy court or the hearing, the creditor's hearing, and simply ask you if you want to keep that collateral. And they will enter into a new contract with you. So if you were paying $50 a month for that refrigerator, now you can reaffirm the contract. You can still keep the product, but now you're going to pay less money. See, the secured creditor probably doesn't want that security back. Let's say you had that washing machine or that refrigerator for a number of years, and what's happened to the fair market value? Has it gone up or down? It's gone down, right? After wear and tear on any type of product, appliance, the fair market value is going to go down. You're not going to be able to sell it for the same price you paid for it. So if you have a Sears card and you go to a meeting of creditors, then there might be a representative there from Sears saying, hey, do you want to reaffirm your contract? Do you want to keep that old washing machine? And you want to pay $25 a month instead of $50? Then you have the right to say, no, come get it, I don't want it anymore. Or yes, I'd like to keep that washing machine or refrigerator, and I will reaffirm that debt by paying less money. What I want you to keep in mind is that if you have an agreement with a person who owes you money and you're supplying the product, or even if it's software, if you have them acknowledge that your contract is a secure transaction, then when you go to bankruptcy court, if that person becomes insolvent, you have a lot more power in terms of getting that collateral back. Now, a prime example of a contract that usually has collateral will be an automobile contract. So if you go to purchase an automobile, and you may hear these radio ads, if you have bad credit, Paul Blanco will still like to sell you a car, and please come in. Now, you're going to pay a higher rate of interest if you have bad credit, but you'll still be able to buy a car, and their contract is very clear that if you don't make your payments, then they can come get the car. That's the collateral. That's a secure transaction. If you go to a rent-to-own store, they say, you know, everybody qualifies, everybody can buy a television or rent a television, but if you stop making the payments, then they can come back and seize that collateral. So something to keep in mind if you are negotiating a contract for goods, products, software, you want that to be a secured contract because you have a higher priority in the bankruptcy court. If you're Visa or MasterCard or some physician or dentist, those are usually unsecured debts. So in bankruptcy court, those are usually going to go away unless you reaffirm those debts. When the representative comes from the creditor into bankruptcy court, most people facing bankruptcy, and even most companies, are trying to liquidate unsecured debt or credit card debt, whether it's the Visa, the MasterCard, American Express, what have you. It's pretty easy to dissolve unsecured credit unless you've used that credit within 90 days of filing for bankruptcy, then that's fraud. Because what the bankruptcy court trustee will say is that you knew you were going to file bankruptcy, but then you took this credit card and you started charging things. I had a client once, and I don't know where he was from, it doesn't matter, but he had come to me for a consultation, and he had filed his petition for bankruptcy, and one of the unsecured debts in his bankruptcy petition was an American Express card. And like the next week after he hired me to fill out this bankruptcy paperwork, he decided to take a trip around the world using the credit card. Now, that's not a very good idea. That's fraudulent. And not only could that set aside the entire bankruptcy proceeding, but he could have ended up in jail, but for the fact his brother-in-law killed him. I don't know, it's kind of a weird story. I'm not saying his brother-in-law killed him because he defrauded the bankruptcy court, completely unrelated. Do we have any questions? Do we have any questions about the difference between secured debt and unsecured debt? Any questions? It becomes a little bit foggy because if you use a Visa card to buy something at Macy's, it could be unsecured, but if you use a Macy's card, that's secured. It's backed by the collateral you buy at Macy's. Just a little bit of a twist. Conceptually, what I want you to understand is that when a consumer, an individual, or a business files for bankruptcy protection, and I say the word protection because Congress enacted bankruptcy laws to protect people and businesses. I'll explain what that means in a moment. Once somebody files, and when I say somebody, I mean a person or a company, once they file for bankruptcy protection, it creates something called an automatic stay. An automatic stay. Think of the automatic stay as this magic fence or gate between the person who's filing the bankruptcy and all their creditors, even secured creditors. For a period of time, no creditor could reach into your bank account. No creditor can file a lawsuit against you. No creditor can take any of your assets, even if they're a secured creditor, while that automatic stay is in place. Now, the automatic stay can be lifted. A creditor could go into bankruptcy court and ask the court for relief, to relieve the automatic stay. So that wall between the creditor and the petitioner moves up, and now that creditor can take assets, file lawsuits, seize bank accounts, take money out of a secured deposit account in your bank, you take money inside a living trust, could take money inside the corporate bank account, right? Now remember when we talked about corporate protection, that protects personal assets, but if there's a creditor who has convinced a judge for relief of the automatic stay, they can grab corporate assets, not personal assets, unless there's commingling of assets or fraud or an underfunded corporation. So often we see this request for relief of the automatic stay in real estate transactions. It used to be a lot of people who were being evicted would file a bankruptcy case to avoid the eviction process or lengthen it. The bankruptcy court and Congress got wind of this about 8 years ago, and they said, look, if you only have an interest in avoiding eviction by filing your bankruptcy petition, we're not going to allow it. You have to have other debt. Well, most people have other unsecured debt, so that's not a problem. They would just add credit card debt or medical bills, and the eviction would be in there. But the bankruptcy code said that if you're only filing a bankruptcy petition to stave off an eviction or to keep yourself in that property longer, it's not going to work. Additionally, what's been happening recently is that, and maybe this isn't so true right now, but about 2 years ago when we had this housing crisis here, particularly in the Bay Area, you had people staying in their homes for a good deal of time after the bank tried to evict them because they couldn't pay their mortgage. So many people, thousands if not millions of people were filing bankruptcy to try to avoid being evicted from their house because they couldn't pay the mortgage anymore. They lost their job, or the interest rate went up, or their mortgage payment went up. They had an amortization type loan, and by the time they knew it, their house was getting devaluated, but their mortgage costs went up. So a bunch of people filed bankruptcy, and the bankruptcy court said, no, you can't file bankruptcy simply to avoid eviction, whether you're a tenant or an owner, an alleged owner in your house, because really the bank owns the house. All right, so this automatic stay provides some protection for some period of time. It could be 90 days. It could be longer. If the creditor doesn't ask for relief from the automatic stay could be 6 months, could be a year. Now, procedurally, what happens is after a party or a corporation requests a filing for bankruptcy, then the mere filing of that petition and the payment of fees, that creates the automatic stay. That creates protection. So there could be an emergency filing by a company or an individual simply to take advantage of this automatic stay, this protection. Some people even do this in divorce cases. Husbands and wives will file bankruptcy to delay the family law proceedings. It doesn't last very long because one spouse is going to ask for relief from the automatic stay. So if I'm a bank, back to this relief concept, if I'm a bank and I'm trying to evict somebody that's not paying their mortgage, I will probably get relief from the automatic stay because I'll just tell the court, hey, look, this is unfair. This person's living in this house and they're not paying the mortgage. We're losing money. So please, grant us relief so we can take the house back, or we can file a lawsuit or do whatever we have to do. Okay? Bless you. Everybody clear on this concept of automatic stay and how it gets removed or lifted? Now, if there is an attempt to remove or release the automatic stay, it's possible it could go back into effect. Or the judge could say, look, you don't have good cause for requesting this relief, and we're going to keep this automatic stay in effect. It could be the court could say that under certain circumstances. So typically what happens after an individual or a company files for bankruptcy, they will get their meeting of creditors in about 90 days. Now, many people file bankruptcy on their own, more individuals than companies, because to hire a bankruptcy lawyer could be expensive. And who could afford to hire a bankruptcy lawyer when you're going bankrupt, right? You have no money, so how are you supposed to pay $2,500 to a bankruptcy lawyer? Doesn't make a lot of sense. So there's a movement, which I encourage to some extent, for people to file their own bankruptcies. It's not that difficult. You can get a software program and do your own bankruptcy. And as long as you make sure that you do it properly, you will get the relief that you're looking for. You'll get the automatic stay, and you might get discharge of your debt, which we'll talk about in a moment. Now, you've probably heard that there are different kinds of bankruptcies. You've heard this on the news. Chapter 7 is probably the most popular, if you will, or commonplace bankruptcy filing. It can be used by individuals and it can be used by companies sometimes. The Chapter 7 bankruptcy is what we call a fresh start, a total liquidation, or a straight bankruptcy. Any one of those terms could suffice. So a liquidation, a fresh start, or a straight bankruptcy. Those terms are all interchangeable, and I would give you credit for any one of those on the final. Think of the Chapter 7 as an opportunity for an individual, and sometimes a company, to walk away from their debt. They just walk away. They file the paperwork, they go to the meeting of creditors, and after they go to the meeting of creditors, where the trustee basically asks 3 questions, there's no judge, it's pretty informal, so a lot of people go there without the assistance of an attorney. They ask 3 questions. Is everything true and correct in your petition? Has anything changed since you filed? And did anybody help you with your petition? And you simply answer those questions. And the 4th question might be, are there any creditors here? Are there any creditors here that want to reaffirm any secured debt, or is there any fraud going on that would prevent this petitioner from obtaining a relief from the bankruptcy court? Like that one client I told you about where he used that credit card to go around the world after he put that in his bankruptcy petition. He had to know that was wrong. Maybe he didn't care. So the Chapter 7 is commonly used for individuals and some businesses that want to basically just fold. They just want to go out of business. The Chapter 13 is most often used by individuals, and we call the Chapter 13 a plan, or the wage earner's plan. About 8 years ago, somewhere around there, 8 to 10 years ago, when George W. Bush was president, through his encouragement and the encouragement of Congress, it became much more difficult for an individual to file a Chapter 7 bankruptcy. If they did not pass a means test, then they may have had to file for a Chapter 13. You see, the Chapter 7 is more beneficial because you wipe out all your debts. And you get a fast discharge. And once you get your discharge, you're the best credit risk in the world because you can't file bankruptcy again for about 7 years. So creditors like Paul Blanco, who love to advertise on the radio, and say, yeah, we'll sell you a car, even if you file bankruptcy, because we know the worst that can happen. If you don't pay for your car note, we're just going to come get the car, and you can't file bankruptcy. You can't hold us up. You can't get that automatic stay. You're the best credit risk in the world. Many of my bankruptcy clients in the past get solicited by credit card companies after they get their discharge. So here's the irony. In a Chapter 7 proceeding, a person could get their discharge in about 6 months. If everything goes smoothly, from the date that they file their petition, after the meeting of creditors, until the date that they get their notice of discharge, that could be a 6-month procedure. However, now here's the irony, the person that's complying with the new law and is filing the Chapter 13 plan has to wait until their plan is completed before they get their discharge. Sounds kind of unfair. Probably can't buy a car, can't buy a house while you're still in bankruptcy. It doesn't make sense. It's counterintuitive. And I don't think Congress thought this out, because there should be some type of reward for people entering into a repayment plan with their creditors. Now, typically these repayment plans are 3 to 5 years, and the debtors will pay their creditors 50 cents on the dollar, something like that. So, as an example, let's do a little math here. Let's assume that there is a $50,000 aggregate debt. Let's say that the debtor, the company, owns $50,000 to various creditors. And if the trustee approves the plan, they're asking to pay 50 cents on the dollar, or $25,000. Everybody get that math? Pretty simple, right? 50 cents on the dollar. Cut it in half. Then, let's say they ask for a 5-year plan. 5-year plan. So on a 5-year plan, they're paying $5,000 per year. $5,000 per year. Okay? After the 5 years, they get their discharge, not before. And they're paying back their creditors, unsecured creditors. They're doing what Congress wanted them to do. So that's probably about $400 per month, roughly, maybe a little bit more. So they're paying $400 a month for 5 years because they make too much money. Every area of the country has a different means test standard. So here in Northern California, it's going to be different than Atlanta, Georgia, or Arkansas, or Miami, Florida, based on